How's the time set for oral argument and cause numbers 1 CACR 17-0306 and 1 CACR 19, dash 0127 PRPC. Those numbers having been consolidated. State of Arizona versus Peter J. Workum. For everybody's information, the proceedings are going to be audio and video recorded, as well as now being live streamed. So barring any unforeseen problems, you can critique yourself in a couple of weeks, which I'm sure you'll want to do. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And for the appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all of your time. However, ultimately, you're reserving that time is your responsibility. We have reviewed the briefs and conferenced the case this morning. So we are well aware of the facts and issues attendant to this argument. And we say that so that you can decide what you want to do with the time you have. Counsel, when you come to the podium, I would ask that you state your name and who you represent for the record. And with that, counsel.
Thank you. Stephen Dichter with Dan Bernardone on behalf of the appellant and petitioner Peter Workum. We will take 12 minutes for our opening remarks, reserve 8 for rebuttal. May it please the court, counsel, our mission here today is to obtain a new trial for Mr. Workum. The issue I'm going to expend most, if not all of my time talking about, depending upon what you all want to talk about, is the ineffective assistance of counsel and its role in this case. As has been said by many times and quoted by your honors, ineffective assistance of counsel must be a demonstrable reality rather than a matter of speculation. Strickland governs the disposition of IAC cases and effective assistance of counsel cases. It has 2 prongs. The first prong is whether they are conduct beneath the standard of care. That was unarguably met. Usually IAC cases fail at this level because the courts of appeal will not inquire behind a conscious decision of a trial defense counsel to offer or not offer an affirmative defense. That's not the case here because, as the PCR judge found, quote, trial counsel erroneously believed that evidence of an advice of counsel defense was inadmissible. And in my mind, the trial judge was being really charitable because what the trial defense counsel said, both in deposition and later in oral argument, in the hearing when he testified, obviously not having availed himself to look at the law in between his deposition and the hearing, was very clearly this. Mr. Dichter, in Arizona, an advice of counsel defense is allowable in a civil case. It's not allowable in a criminal case, to which I mustered my 48 years of criminal law experience and said, oh, really? How interesting to learn that, as the judge rolled her eyes. So the first part of this is resolved. If the lawyer not only didn't know the defense was available, but affirmatively believed it was not available because this was not a civil case, even though he had described the case itself as a civil case masquerading as a criminal case.
But here though, didn't Judge Gates rule based on the second on another issue, which is, sure. Yeah, there was ineffective assistance because it is a defense.
Right.
But didn't she compare the stories of the civil lawyer, Mr. Collins, as to the extent he gave them in a declaration and an interview, and didn't she conclude that he didn't have all the facts? And if he did have the facts, couldn't she have concluded that he was an accomplice, not a lawyer?
Well, that's really interesting. And I've been wondering for years whether anybody would say that. But our colleagues answered that question in the hearing during which Mr. Collins' lawyer, Bruce Fetter, said he's going to take the Fifth Amendment because the state had subpoenaed him to the Rule 32 hearing, and the state answered, well, he didn't do anything wrong. And Fetter said, well, the Fifth Amendment is to protect the innocent as well as the guilty. So, yeah, one might wonder that. But
in a Rule 32 proceeding, it is your burden to show that your client met all the elements for an advice of counsel defense.
no, I disagree. I absolutely disagree, Your Honor. In a Rule 32 hearing, it
You
is
have
my...
to show prejudice, which means you have to show you would have had an admissible defense that could have been presented to the court.
Yes, and the court never said I didn't have an admissible defense. What the court did was weigh the evidence of that defense, usurping the right of the jury to decide the defense. This is absolutely fundamental. An affirmative defense under Arizona law is statutorily governed under ARS 13-205, and it is for the jury properly instructed to decide. What the judge did here was, having satisfied herself on the only questions that were necessary for her to decide as the gatekeeper of the affirmative defense, and there are only two questions. One, was Matt Collins a lawyer? And was he consulted with?
No, I
And
think
she
there's
found
more
it
than that
both.
in order to establish a defense, the defense of counsel,
Yes.
advice of counsel, there's more that has to be established.
Yes, but to a jury, not to the judge.
Now, in order to get the instruction, you have to meet certain requirements.
In order to get the instruction, you have to bring forth some evidence on each element.
Right.
Some evidence on each element was brought forward.
Was
What
it?
the judge-
The court below found that you had not presented some evidence that all the relevant facts had been presented.
No, the court below found that she didn't believe all of the evidence. She didn't say that evidence on each element hadn't been presented. She said it hadn't been presented to her satisfaction. And I just disagree, Your Honor, that that's her duty. The Constitution of the United States and the statutes say it's the jury's determination of an affirmative defense. Did she say in the proceeding that the evidence we offered was inadmissible? No. Did she say it was incompetent? No. She weighed it. That's not her job. Her job was not to weigh the evidence. The jury's job was to weigh the evidence. We must proceed as if a competent lawyer would have presented an advice of counsel defense. And what's additionally a little unfair about that comment, Your Honor, is the following. We were time limited in the Rule 32 hearing to present the tops of the waves. What do we need to show to get a new trial? This was not the 3 or 4 or 5 days that would have taken to present an actual advice of counsel defense. We were not charged with the responsibility of presenting an actual advice of counsel defense at the Rule 32 hearing. We were needing to present enough to show that the result, there was a reasonable probability that the result would have been different. Now, is advice of counsel a defense to the 6 charges that went to the jury? Unequivocally, absolutely. Because each of them required a showing of specific intent, willfulness, intentional conduct.
But did your client offer evidence in the PCR proceeding that Mr. Collins advised him about the CTP transaction?
Well, not only did we offer evidence that he advised him about the CPT transaction, Mr. Collins set up the CPT transaction, which is another place where I'm simply afraid that our appellate papers are frankly better than what the court's evaluation was. This is not a situation, and you said it yourself, this is not a situation in which the lawyer sitting in his sterile chair receives a client and the question, shall I do this, shall I do that? The lawyer pontificates, do this, do this, do this, do that. The lawyer did 90% of what happened, which leads to why you led to the question of, well, couldn't he have been charged as accomplice? Maybe he could have been, but that still doesn't negate the fact that my client would have had an advice of counsel defense. It would have been an interesting defense to present. It would have been an interesting defense to present if the lawyer took the Fifth Amendment, which the lawyer did, which suggests what? Well, I know you have your missing witness rule and you say you can't hold it against the state because it refused to immunize somebody. But still, why did the lawyer take the Fifth Amendment? Because he did all of this stuff. And not only that, We didn't rely simply on Workum's word as to what the lawyer did. What we did in the evidentiary hearing, through painstaking introduction of publicly filed papers, was to show that the lawyer, in fact, had prepared the Articles of Incorporation, had prepared the change in the Articles of Incorporation, had prepared the deeds of trust, had prepared the deeds of trust that, or the deeds of release and reconveyance that remove the encumbrances so that CTP's funding mechanism could be recorded, and then re-recorded after that the deeds of trust protecting the other interest that was secured in the case, the interest of Owen Farnsworth after my client had been paid off by borrowing money on the property. So the fact is that no, respectfully, you're incorrect. Just incorrect. The judge had to decide the following. Was Collins a lawyer, and was he consulted with? Every other determination would have been for a properly instructed jury. I mean, just think about it as if the defense
But
of
that's
advice...
not how ineffective assistance of counsel claims work on Rule 32 or habeas or anything. I mean, there has to be a determination of prejudice, and we defer to trial courts to make the determination whether there were facts that are sufficient that a reasonable jury could reach this conclusion. There's not a right that the minute someone says, I could have presented a defense, that means we give them a new trial every time. That's not what you're arguing.
Yeah, I mean, I hear what you're saying, Judge, but what you've just done is essentially advance Rule 32 ahead of ARS Section 13-205 and the United States Constitution. And if you wish to do that, I'm powerless to stop you.
I'm not advancing. I mean, this is how it's worked for dozens and hundreds of years.
You have never seen a case like this, I submit, Your Honor, not one time. You have never seen a case in which the lawyer basically proclaims, not that, look, if there'd been a disagreement...
So no matter how fantastical, and I'm not saying yours is fantastical, this is a very compelling case, and I'm not arguing with you on that, but you would say no matter how fantastical, as long as someone says, look, counsel could have presented this defense, had a mistake of law, they didn't think they could have, that means we have to give them a new trial?
No, absolutely not. What if the offense had been...
So there's going to be some weighing of the merits of that trial by the trial judge?
No,
that
because
defense by the trial
you've
judge.
gone off on the wrong point here. It's the offense that leads to the defense, not the defense that leads to the offense. So let's say this had been a bank robbery case.
Wait, walk me through that again, I'm not sure.
This was a bank robbery case. The defendant robbed 6 banks. He goes to his lawyer, he says, I robbed these banks. The lawyer says, the banks have preyed on the people of this country for 300 years. You were entirely justified, I say, as a matter of law and of right to rob these banks. Now, there you go. No advice of counsel defense. But these offenses are scheme and artifice defenses in which it's not a bank robbery at all. It is documents creating legal entities to do legal things that only lawyers know how to do.
What is your, I see your time by your self-reservation as a lapse. What is your best case that will help me understand your position on burdens of proof and the role of the trial, of the PCR judge?
Strickland. Because Strickland overarches your our Rule 32. It just does. And it says, was there a reasonable probability, had this defense been presented, that it might have made a difference? And that cannot be contradicted in the type of case that this was.
So reasonable probability, that's the question for the PCR judge.
Yeah, well, that's the question for the PCR judge without usurping the function of the jury to determine the facts of the underlying affirmative defense.
But what case tells us where that line is drawn?
There is no case that tells you where that line is drawn in Arizona because this case has never existed in Arizona in this fashion. Every ineffective assistance case founders on the, well, it was the decision of the lawyer not to present it.
You never get to this.
And you don't get to this. Thank you.
Good morning. May it please the court, Michelle Hogan, representing the Attorney General's Office for the state. This court.
I'm sorry. I'm sorry. That's okay. What did you just say? Can you reintroduce yourself?
Yes, Michelle Hogan for the Attorney General's Office for the state.
Thank you.
This court should deny Workum's claims in his petition for review just because there wasn't any deficient performance. First, this advice of counsel defense is not a recognized defense under Arizona law and certainly not an affirmative defense. We've abolished all common law defenses and affirmative defenses are statutory.
So I don't think I saw that in your briefs.
It was argued down below at the PCR court in closings that this couldn't have been a defense to the charges. It was not raised because the trial court found that it could possibly defense. I think be a defense. The state said, well, assuming even if it was a defense.
But you didn't raise this in your response or your answering brief, did you?
No, it wasn't raised.
I think you should focus on stuff that you raised in your brief.
The only reason I bring that up is that I wouldn't want a suggestion that we have a defense under this law since this court's memorandum decisions have persuasive value, and it would just be a misstatement of the law to assume that this is a defense under the law.
So you're saying Judge Gates was wrong in finding the first prong?
Right. And I mean, there's other reasons besides the fact that it's not a defense under the law, but Mr. Townsend wouldn't have been deficient for not raising this defense because he testified that he reviewed the attorney who purportedly advised Workum's interview, his pretrial statement, and an affidavit. And in that pretrial statement, the attorney said, I provided some forms to form this company. And in his interview, he denied knowing any of these underlying facts of the case.
Now, he is Collins or trial counsel?
Matt Collins.
Okay.
He denied knowing these underlying facts of why Workum needed these forms to form DeVeris LLC. And so Mr. Townsend testified at the evidentiary hearing. He didn't believe that Matt Collins would testify at trial. I advised Mr. Workum to proceed a certain way with the formation of DeVeris, and I told him it was legal. So
you're arguing that they went to him, he simply said, these are the documents you need, as opposed to these documents will make this legitimate.
Correct. That he had no idea that the victim had quitclaimed a home into a non-existent LLC, and that Workum, he never said that Workum told me about this underlying business agreement, and then I knew all these details of this purported business agreement below. So,
but I think what Mr. Dichter is saying is that was for the jury to decide because Collins was not put under oath and put to that test.
yes, but we're looking at what a reasonable attorney would have done under these circumstances, and knowing that Matt Collins, at least according to his pretrial statement, wouldn't support this advice of counsel defense. It wouldn't be deficient to proceed on the defense that Corwin chose, or Mr. Townsend chose, which was my client didn't have the intent to defraud because the victim and the defendant had an oral agreement that the victim's house would serve as a security interest.
So are you making the argument that it is just unbelievable that Mr. Collins would have recommended that Mr. Workum engage in this scheme?
Right.
Or are you arguing that as a factual matter, Collins was not advised of all the facts?
I'm just saying under the facts that Mr. Townsend had before proceeding to trial, it would be reasonable to present the defense that he did and forego an advice of counsel defense because according to Matt Collins's pretrial statements, he wasn't going to support an advice of counsel defense. So the only way an advice of counsel defense could have come out at trial was through the defendant, Mr. Workum. And Mr. Townsend testified he didn't believe that Mr. Workum would appear to be a credible witness in front of the jury. And
If what? He would not appear to be a credible witness if.
oh, I'm sorry, because he didn't have answers to a lot of questions, he said, and he thought the jury would perceive Mr. Workum to be too slick. So was this reasonable for Mr. Townsend to present the defense that he did and forego this advice of counsel, this potential advice
But the
of
trial
counsel.
court's gone beyond that. The trial court has said it's ineffective not to have realized you have a defense. So the trial court said, okay, would the defense have worked? So
Yes.
what did Townsend know about what Collins would say specifically?
What he knew before trial, and basically it's limited to the affidavit that Mr. Collins provided and his pretrial statements. And in there, Collins denied knowing these underlying facts of the deal and only providing forms. And he even said, Mr. Collins said in his pretrial interview, that if he had known all these underlying facts, he wouldn't have even provided the forms and participated at all in creating Diveris LLC.
Because?
Because he believed this conduct was illegal. So he wouldn't have provided the form and assisted Mr. Workum in forming these companies and releasing deeds if he had known all the facts.
He wasn't going to facilitate something if he had the facts to know that he was actually facilitating.
Yes, that's correct.
So Workum would say, I did so tell Collins all these facts, and Collins helped me out. Collins was in there. I was following Collins' instructions. Why isn't that, under the cases, why isn't that a question of fact for the jury?
Well, I think that when we're moving on to I guess we're going to prejudice, the second prong. I mean, we still need to consider the trial court's findings. She assessed Mr. Workum's testimony at the Rule 32 hearing in the context of everything that was presented at trial. So, I mean, that is putting it in the context of, is there a reasonable probability that this would have somehow affected the outcome of the verdict? And when she considered that with conflicting trial testimony and Mr. Workum's testimony at the evidentiary hearing, she found that there wouldn't have been prejudice because Mr. Workum was not credible on these points and hadn't even met all the elements of an affirmative defense of advice of counsel, if we're assuming that's a defense under the law.
She said, we're assuming that he didn't meet the elements of an advice of counsel defense only if you don't believe him.
Well,
Is that
part because his testimony about the deal, his pretrial statement in his affidavit, his pre-hearing affidavit, and his testimony evolved. And also she compared it to the testimony that was presented at trial and said, well, there's this conflicting testimony with Mr. Workum. So she did assess it under the reasonable probability standard and found that this wouldn't have caused prejudice.
what's a case I can read that will help me understand what fact-finding or what credibility determinations are for the PCR judge in this context?
Well, we have cases that say that in this context, we defer to the trial court's factual findings unless they're clearly erroneous, like, and at evidentiary hearings like this, the trial court is the sole arbiter of witness credibility, and one is State v. Fritz, which is 157 Arizona 139.
What's that case? I'm sorry.
State v. Fritz.
F.
F-R-I-T-Z, 157
Okay,
Arizona 139. And State v. Hess, which is 231 Arizona 80. And in that case, they said by considering the credibility of a prospective witness at trial, the trial judge does not usurp the function of the jury. And here, I mean, she did put it in the context of if this had been presented at trial, look at all this other evidence that conflicts with Mr. Workum's testimony at the evidentiary hearing.
One of the things that defense counsel talks about that I find pretty compelling is that this hearing was rather abbreviated, and they were providing basically broad outlines of the defense they would do, and weren't really given the opportunity to present the entire meat on that bone, so to speak. Could you respond to that in any way?
It was a day-long evidentiary hearing. They didn't ask for more time, and what they did is present, and the only way they could present this testimony or advice of counsel defense through was Mr. Workum. So, I mean, they presented everything they could through him. That's the only witness that could testify to this at the hearing. So, and he had trouble at the hearing, Mr. Workum had trouble even stating what exactly he told this attorney, Matt Collins, before he started this whole conduct of taking the victim's house. So I think there was enough for the trial court to determine whether A, there was deficient performance, and B, whether there was prejudice in not presenting this defense.
Counsel, I want to ask you a question based on what you just said. You're saying that counsel would have changed the timeline a bit? He would have said that at the time all these processes started that he had not even given advice at that point? Or are you, I want to hear. I mean,
Yeah.
at what point does counsel's conduct become an issue in these proceedings? Before all these forms were created and all this stuff was set up, or after?
He claimed, through his evidentiary hearing, the defendant claimed before he started his actions, he sought counsel's, Matt Collins' advice. It's not really, obviously, from Matt Collins' pretrial statements. I mean, they conflict with that. And according to Matt Collins, the only way he thought they were trying to recover this money from the loan was through a involuntary bankruptcy proceeding, that he didn't realize that the formation of DeVeris and the filing of all these deeds of release and trust had anything to do with this business, or at least a purported loan below. So, I mean, that's all we have, and for Workum testimony to support this. But again, I do think that the court should reach the threshold issue of whether this advice of counsel is actually.
But you haven't given us any authority for that.
Well,
And it would be unfair to give it now, wouldn't it?
I would just say that all the cases that were cited by both defense and the state that suggest that there is an advice of counsel defense are primarily tax evasion cases that have a requirement that the government prove willfulness. And under those cases, the term means that you are acting to violate a known legal duty and you're not acting out of mistake or an accident. And it's particularly applicable in tax evasion cases because you do have to prove willfulness and that they knew that they had this obligation.
But aren't these intentional crime? I mean, isn't the mens rea in these crimes the same?
We have the knowing intention, and when you look at the Raji for knowing, it states it does not mean that a defendant must have known that the conduct was forbidden by law. So there's no requirement for the state to prove that at trial. So proving an advice of counsel defense isn't relevant to any of the elements that the state has to establish at trial.
So, go ahead.
And the Raji also says ignorance of law is no defense. And I mean, this is essentially a glorified ignorance of law defense. And also, I know that the trial court said Corwin should have known, or Mr. Townsend should have known about this defense. But when we're looking at Strickland, we have to remember that we're not just considering whether, just because the chosen strategy failed, well, now in hindsight, maybe this defense would have been better. We're just looking at whether a reasonable attorney would have proceeded to trial on the defense that he presented and foregone this advice of counsel defense. And I think the answer here is yes, a reasonable attorney would have acted the way Mr. Townsend did because of Matt Collins' pretrial statement and his trial counsel's determination that Mr. Workum would not serve as a credible witness at trial for various reasons, and like would come across as too slick, wouldn't perform well on cross-examination. So we don't even need to reach prejudice because Mr. Townsend wasn't deficient for foregoing this defense and proceeding the way he did. If there's no further questions, the state rests on its brief. Thank you.
Thank you. Hess is a newly discovered evidence case. It's not a constitutional case, so Hess doesn't count. Fritz was a case in which there was a guilty plea, which then was sought to be taken back on the basis that the victim, the minor's sexual conduct or sexual abuse victim, had recanted. And the actual statement of the Fritz court was when the state argued that the court should just disregard what the victim had said in recanting her inculpatory statements towards the defense, the state said disregard those, and that's where the Fritz court said, well, no, the court is the terminator of the, or determines the credibility of the witness. In our case, had there been a controversy between Townsend and Workum, with Workum saying he was supposed to present advice of counsel defense, and Townsend said, well, no, we talked about all of that and so on and so forth, and we decided jointly not to do that. Then, Judge Morse, the judge would have determined the credibility of Townsend versus Workum to decide whether or not Townsend's conduct had been deficient. And that's where the credibility determination comes in. That wasn't necessary, as you said, Judge Johnson, in this case, because the court went way past that. The court didn't try to support what Townsend had done. And by the way, it is to be noted that Townsend had subpoenaed Collins to the trial. He sat him there for a whole day with his lawyer out in the anteroom. It is a mystery to me why he did that, since he said there is no such thing as advice of counsel. But the fact is that he said there was no such thing as advice of counsel, and everybody goes forward with respect to that. The issue about Townsend not having Workum testified was an apple versus a pear. If there had been an advice of counsel defense, then Workum would have testified, because there would have been no other way to present it other than through Townsend, who, although he showed up for the trial, he showed up with able criminal defense counsel, different than the one who was at the time of the evidentiary hearing. And who knows whether she would have let him testify or not. Another witness in this case took the Fifth Amendment. The judge let the Fifth Amendment be taken in front of the jury. In terms of Collins, well, it's just delicious. I had 100 exhibits to pound Collins' face in had he shown up at the evidentiary hearing to testify, or if he shows up at a trial to testify.
So, but here's the question that I'm struggling with. As you say, this is the unusual PCR. What I'm used to seeing is a petition for review where the defendant says, I found all this newly discovered evidence, and the trial judge in the PCR proceeding says, it wouldn't have made a difference. Assuming it exists, it wouldn't have made a difference. I was at trial, I know. How is that different? We do that, we accept that all the time.
Because advice of counsel, as you looked at the state's counsel in wonderment when she said, well, it's not a defense in Arizona. That's astounding. Of course it's a defense in Arizona.
Okay, accepting it's a defense.
Okay.
Newly discovered evidence might be a defense.
But how would it have made a difference? Because the defense of advice of counsel was peculiarly appropriate to what the counsel's advice had been. Every single paper that had to do with the defense of advice of counsel had to do with the underlying transactions. The lawyer prepared the papers to incorporate the unincorporated DeVeris LLC. In other words, the lawyer, as Workum testified, found, how would Workum have found this? The lawyer found that DeVeris LLC wasn't incorporated in Arizona, in Utah, where he assumed it might have been incorporated based upon certain cultural things in this case, or Nevada, where people often incorporate, for the simple reason that you don't have to say anything about incorporating if you're incorporating in Nevada, other than I've incorporated in Nevada. People hide things in Nevada like crazy. I'm admitted there. I do understand that. Now, in this case, Collins prepared everything. And the time that he was interviewed, now think about what all of this involved. This involved title companies. This involved deeds. At the time that he was interviewed by the state, and he dodged the interview for weeks and weeks until they threatened to serve him with a notice of deposition, which they were entitled to do. And even our lawyer at the time, which was the lawyer before Townsend, was exhorting Collins to show up for the interview. He had just taken a new job as in-house counsel for First American Title Company. Oh, how delicious I've only been at this 48 years and had about 100 and something trials, most of them criminal, and lots of them as a prosecutor for the federal government. How much I would have salivated to have had Matt Collins on the stand. Let him deny whatever he wanted to deny. He filed a bankruptcy pleading under Rule 11, which is Rule 7011 in bankruptcy procedure, in which he related everything that had happened under his signature, including the involuntary bankruptcy plan and the other plan with the deeds. It's all in a pleading he filed in bankruptcy court in June of 2012, 4 months before my client was indicted by the state. It's all there. Collins, whether he had shown or not shown, would have been tar baby for me in this case. I would have pounded him in this case. Any competent lawyer would have pounded him in this case. And the more he denied, well, he couldn't deny everything because we had the declaration, which was, of course, like pulling teeth. He gave only as much as he wanted to give, but it was a voluntary declaration. How much more would he have given under oath? He would have either taken the fifth or he would have told the truth. Either way, I win. Either way, I'm successful. Townsend wasn't successful because he didn't know there was such a thing as an advice of counsel defense in a criminal case. What else can be said? This is a case of this is a structurally defective defense. This was the only defense to the charges. He didn't put it on. I will put it on, and you should give me the chance to do it.
Thank you, counsel. Thank you for argument today, folks. We are completed at this time, and we are going to adjourn. And we will issue a ruling in due course. Thank you very much.
Thank you.